Hi. Hello. Good afternoon, everyone. I'm here. I actually work outside in San Francisco, directly across from the Pixar campus, would you believe? So I get to stick my head out my office window and watch people take pictures in front of the Pixar gate. That's fun. But I'm here today, and before I get started talking about all this, how many of you have gotten a patent, been through the process? Okay, one. Any particular interest here? Thinking software, mechanical? Okay. Well, let me ask you a question before I even flip the first slide. What is a patent? Can anyone give an answer here? And those of you in the first row, you're going to get picked on. Sorry. No guesses? No offers? Well, all right. Next slide. So a patent is basically a bargain between an inventor and the government. The inventor discloses his or her invention in such complete terms that someone could go out and build one if they wanted to from the description. And in exchange for that, the government grants the inventor the right to stop other people from making, using, or selling the invention for some defined period of time. Now, right now, that period of time is 20 years from the earliest filing date, not counting provisional applications, which we'll talk about later. So typically you get about 17 years of time. So, now, patents are constitutional in origin. They are right in the Constitution. Article 1, Section 8, Clause 8, when talking about Congress's powers, the founders of the Constitution grants Congress the power to give inventors this right to their invention for limited periods of time. So it's controlled by federal law, and in this country, it's administered by the U.S. Patent and Trademark Office, which is in Alexandria, Virginia. They just started new satellite offices in Detroit and San Jose. We have no idea what they're going to do with those offices, but they're there. Okay. So next basic issue is what can be patented? Well, the threshold law says that any new and useful process, machine, manufacture, or composition of matter, or any new and useful improvement thereof. Very legalistic language, but the Supreme Court's interpreted this over the years, and what they've decided is that anything under the sun that's made by man, in the gender-neutral sense, can be patented. Lately, there has been a lot of dispute, a lot of court cases about the patentability of DNA, about the patentability of medical treatment and diagnostic techniques. But other than that, just about anything you can think of, as long as it's tied, if it's a business method or a piece of software, as long as it's tied to a computer, as long as it's something like that, it can be patented. Next slide. So, why would you want to get a patent? Well, there are a lot of answers to that. The fact of the matter is, patents provide credibility for companies, particularly small and startup companies. In my business, I really focus on independent inventors and small companies, people who have never talked to anyone legal before. And when I work with someone, the patent might be the company's first actual asset that's really worth something. Patent pending. In our culture, there's sort of a cultural predisposition toward patents, and we use them for the phrase patent pending. People tend to think your invention is high tech, that it's worthy, that it should be looked at, that it should be purchased. And I've seen a lot of very bright marketing people make a lot of hay with that. But really, in a legal sense, a strong patent portfolio provides assets that can be licensed or sold to generate revenue. And if you are sued for patent infringement, if a company comes to you and says, I think you're infringing this patent of mine, you can go back to them and say, okay, I think you're infringing these 5 patents of mine. Now, do you want to sit down and talk about this, or are we going to have trouble here? Fundamentally, a patent is a piece of property, and you can do with it anything you can do with a typical piece of property. You can license it, you can sell it, you can mortgage it, all things that can be done to generate cash. I don't know if you've been reading the papers lately, but there have been a lot of deals where a company will buy another company, and really what they want, they spend $1 billion for about 800 patents that this company happened to have. So,
quick question.
Yeah, go on.
On the patent pending, the legalities of using those 2 words,
Yes.
Is there any laws, rules, obviously historical, moral issues related to using that? Let's say that, I made this and I plan on getting it a patent agent and, going through the process, but I haven't yet. So I'm going to put patent pending just to keep people at bay for a minute. Is that legal? I'm not saying I can do that.
I think, okay, so the question is, when is it appropriate to use the phrase patent pending, and can you do it before you actually get a patent, before you actually apply for a patent? And my answer is that I'm not an attorney, and I'm not an attorney in this state, so I can't give you a precise legal answer. I suspect there might be some issues with false advertising. Not sure about that. Don't quote me on it, not sure. What I can tell you is that as soon as you've applied for some kind of patent, it is appropriate to use that phrase. And the other reason why I wouldn't do it is because if you use the phrase patent pending, someone might come along and say, okay, well, prove to me that you've got a patent pending. So it can get sticky. All right, so thank you, by the way. A couple things I want to get out of the way, the depressing stuff. Get out of the way early, right? So getting a patent is, first of all, not cheap, and it is not quick. And those two things are very important to understand. 3 to 5 years, typically, is the time span for actually getting a patent from the government. And I see you shaking your head back there. You're absolutely right. Yeah, the problem that I have is that some person will come to me with this great software invention, and I'll say to them, okay, well, you're using this feature in version 1. Could you see using it in version 5 or 6? Because unless you're still using it in version 5 or 6, then it's not going to be much use. Now, I have seen cases where it's worked out very well. Like, for example, I had one client who invented a speech processing system, a computer-based speech processing system, back in the mid to late 90s when those technologies weren't common. And nowadays, everyone uses speech processing and speech recognition to process calls and call centers, for example. Please tell me what you'd like to do. If you'd like to talk to so-and-so, say, that kind of thing. And that client has done relatively well with his portfolio. But there are a lot of cases where just the time spent, the amount of time it takes to get a patent, can render it useless. The other thing is it's super expensive. I'm not cheap, and attorneys are even more expensive. Typically, to get a patent in the US, they can run $15,000 to $20,000. Now, that depends on what mood the patent office is in and what they ask you for once you submit the application. And we'll talk about that in a moment. But it's a lot of money. And if you're selling your product outside the United States, US patents protect the invention only within the United States and its territories. If you're selling in Europe, I gotta go talk to my guy in Europe for you. If you're selling in South America, we gotta go talk to those people. So it gets very, very, very expensive. And once you start the process of especially foreign patents, it's kind of like a Pandora's box cost. Now, I can run estimates for clients. I can try to help you anticipate what those costs are going to be, but any way you cut it, you're going to need some money. Next slide, please. So the next question is, go ahead.
Are the costs mainly attorneys' fees and those, or is it the actual application that costs?
Well, it's when you're paying for a patent application, there are like 3 different things you're paying for. Number 1 is the government filing fee, whatever government it is. Number 2 would be patent drawings, illustrations to go with the patent. But yeah, a lot of that is attorney time. And to give you just a quick, most attorneys, most firms, if you walk in, on average, $300, $350 an hour. Pretty expensive. I charge the measly rate of $185. So yeah, that is. But the next question is, it's also a matter of timing, because if you pursue a patent too early, before the invention is fully conceived, then you can burn up a lot of cash before you're really ready for it. So I'd like to tell a story. I deal with clients all over the country, and I have clients from a lot of different places who call me up and say, I have an idea. And I said to them, okay, well that's great. Can you tell me how to make your idea work? Can you tell me how to implement it? And they look at me and they say, not really. I'm like, well, okay, I can maybe do some background research for you and help you out a little bit with that, but you're really not ready to go for a patent until you can tell me how to make your idea actually work. That's the difference between an idea and an invention. However, people from Montana call me up and they say, by and large, hey, I had an idea. I made 10 in my fully equipped garage machine shop. How many would you like me to send to you so that you can evaluate it? This is why I like it from Montana. Now, you also, although you want to wait until the invention is fully conceived. You want to wait until you know what the parts are going to be and generally how they're put together. You want to try to apply for a patent before the invention is disclosed to the public. I'm going to follow up on that in just a moment. See, US patent law did recently change. From time immemorial until about 6 months ago, actually no, 3 months ago, we were giving a patent to the first person to invent whatever the invention was, not necessarily the first person to file a patent application. The US was backwards in that way. Everywhere else in the world, first person to get to the patent office to file a patent application gets the patent. Finally, in March, we changed the law. Now, the way it works is, in the United States, there's a grace period. If you disclose the invention, by the way, by disclosing, what do I mean? I mean putting it on the web. I mean talking about it at a conference. I mean just talking about it in any kind of general setting where people are not bound by confidentiality. That's a disclosure. In the US, even under the new law, there's still a 1-year grace period if you, as the inventor, disclose something, or if someone discloses it for you and they got the information from you. However, the courts really haven't worked out the boundaries of what that means and what's okay and what's not under the new law. We're kind of going on what was okay under the old law. So best practice is to file a patent application before you publicly disclose. The other reason for that, which I've noted down here, is that the US is one of the only countries that gives this 1-year grace period for filing. Foreign countries mostly are not that nice. For example, there's no grace period in Europe unless you disclose the invention at a World's Fair. I think that's one of the few exceptions in Europe. So if you disclose your invention before you file a patent application, then you are most likely going to lose your foreign patent rights. And even if you're only a US-focused business right now, even if you only sell in this neighborhood, you really don't know where your business will be in 5 or 10 years. It's possible that those rights will come in handy. Why? All right. So let me step into more specifics here. Talk first about the types of patents. And there's actually 3 types of patents the US government grants. The first one is the one that most of us think about when we say patent. And that's a utility patent. A utility patent covers the structure of an invention, how it functions, how it's used. Sort of like I could get a patent on this chair here and how, and on the legs and on the structure of the back. So that's what most people think about. However, as anyone who has a Mac laptop or an iPhone or a Samsung knows, industrial design is very important. By industrial design, I mean how a product looks, the aesthetics of it, how form and function kind of meet. There is a separate type of patent called a design patent that covers the aesthetic look of an object. So I've gotten design patents on couches. I've gotten design patents on chairs. I've gotten design patents on dolls. All sorts of different things. That's important. Now, there's a third type of patent also that's very rarely used. In all the years I've been doing this, I've never done one, but it's called a plant patent. And they're offered for asexually reproduced plants. Mostly plant patents are used for hybrid roses. Rose growers will seek to protect their invention by applying it to a plant patent. Let me give you a couple of examples. And first example of a utility patent, I'm going to introduce you to my friend Chucky here. I decided to name him after the horror movie character. A couple of years ago, I was working with some doctors at Johns Hopkins who were seeking to train obstetricians to deal with certain birthing complications better. And they realized they didn't have simulators good enough to train these doctors because the simulators they had were not anatomically reliable. So Chucky here is a fetal simulator. He has actual shoulder blades and clavicles that move around. He's got a neck that can be pulled up and down and out and move around. And he's also got sensors that let the simulator know how much force the obstetrician is putting on it. I got this patent in 2008. We actually had to go to the patent office to talk to the patent examiner about it. We get up to the security desk, and they x-ray everything coming in the building. And they took an x-ray and they went, "What is that?" And then, even more fun, the doctors set up the simulator on the patent examiner's desk and delivered a baby. That was a fun one. Now, unfortunately, the folks I was working with didn't have my sense of humor, and they actually said to cover the simulator with a towel as we were walking down the hall, because the other part of the simulator is an accurate representation of the lower part of the female anatomy, of course. Next one. Something a little more sedate. Example of a design patent. This is a bag or a purse And we got a patent on the aesthetic look of it. And you can see a design patent is basically the drawings. What you see is what's protected. So design patents are typically considered to have a relatively narrow scope of protection. If something differs even a little bit from what's shown in the drawings, then it may not be covered. But design patents do have their uses. In the recent litigation between Apple and Samsung, Apple prevailed on its design patent for phones. And you'll notice here that certain of the features are in dotted lines. That's my way of telling the patent office, we don't care what this feature is, it can vary in appearance from design to design. Now, the other thing I want to point out on the next slide is that you can get a design patent and a utility patent on the same product if it's got aesthetic features as well as functional ones. The purse I showed you in the last slide certainly has a look to it, but this inventor figured out you can put a drawstring channel in the panel of the purse, and then you can fold the purse up and make it into its own little bag. This is also great for sweatshirts. You got a sweatshirt you don't need anymore, you fold it up, draw the drawstring, and it's its own little pouch. So we got a utility patent, actually just recently, a couple months ago, on that aspect of it. So you can have multiple types of patents in the same thing. Next slide, please. So I'm going to take you through the process of actually getting a patent and tell you war stories. But to start off with, I wanted to talk about a little bit about what you would need before you're ready to sit down with someone like me. And what I've found is that some form of written description of what the invention is useful. Something I can look at, read, think about, formulate questions. It doesn't need to be extensive. A sentence or two, a paragraph or two, whatever you've got is helpful. I have literally worked from the stained cocktail napkin. I worked with that. I've worked with people who send me mechanical drawings of things, and okay, it's round. Now what am I looking at? If you do a written description, though, I have some clients, some people I've worked with who are very earnest about it, and they try as hard as they can to make their description to me look, sound, and feel like a patent. And the problem with that is they spend so much energy making it look and feel and sound like a patent that they forget all the details of their invention, and all the details that need to be in there aren't there. So whatever you've got is good, but some kind of sketch, some kind of written description. And it's more important to get the critical ideas. What is the invention? How does it work? What are the parts? Than to try to get everything in there. Let your patent agent or your patent attorney, and we'll talk about who they are, flesh it out with you and talk it through. Okay. So, case study. Now, unfortunately, I did not bring one of these with me today. But I had a client a couple years ago who came to me with a plush doll, a stuffed animal that had interchangeable parts. And I met this guy when he was burning through sewing machines, trying to sew multiple layers of this fur together. Ultimately, I think he found a place in San Francisco, not too different from this place, with some manufacturing capabilities and a kind of collective workspace, just like this, and he refined it. So I took on this case because I deal with all sorts of high-tech stuff. I've done software, I've done genetics, I've done biotech, I just did some plant biochemistry. Every so often, it's nice to just relax and have some fun. So this case was fun for me. Next slide. So he comes to me with this doll, and it's basically furry thing that has openings you can attach parts. So what do? And this is in general, what do when you have an invention and you want to see whether to go forward or not? Usually, my first step with most clients is what I call patentability search and opinion. What I want to do is go out there and find all the stuff that could stop them from getting a patent. Look at it and say, okay, now that we've looked at what's out there, can you have a patent or not? And to explain that, when I'm looking at whether or not someone is entitled to get a patent on their invention, it's mostly two things. Number one, is the invention novel? Novelty is pretty easy to understand. It means, has someone done it before? If the invention is out there, you can't have a patent because what you've invented already exists. So, too bad, so sad, very sorry. The other requirement is not as easy to figure out. It's squishier and it requires a judgment call and a lot of legal knowledge. And that's obviousness. What the law says is that even if your invention is novel, even if it's new, you can't have a patent if someone of ordinary skill in the field, whatever field you're in, would have figured out what you did from all the stuff that's already out there. So to do that, we have to look at the references and see what they show. The example I like to give is, let's say, you all know the little red wagon that kids drag behind them. I'm seeing nods. Okay, good. So let's assume that that's out there in the world. And then let's assume that someone comes to me and says, Andrew, I've got the best idea in the world. It's a little blue wagon. Okay, show of hands. Who thinks it's patentable? Raise your hand. Okay, nobody thinks it's patentable. Good. That's probably the answer. If, a change in color really isn't different enough to warrant somebody getting a patent, because patent's a pretty powerful thing. But now assume that along with a little red wagon, I found 15 articles from leading experts saying either that I can't get any color of paint to stick to a wagon except red, or wagons must be red for safety reasons. No one can ever make a wagon any other color. In that case, my client might have a case for getting a patent. So you've got to look at all these aspects. And in this case, we found that it was patentable. So what do you do next? Well, okay, obviously we could have gone for a design patent here. But the problem is that this thing can be any appearance. You can put whatever features you want on it. So design patent covers one design that would have been a prohibitively expensive and not very useful way of going at it. So what we decided to do is we went for a utility patent. Now, with utility patents, there are two types. In the mid-90s, the US created a new type of patent application called a provisional patent application. And a provisional patent application is a simpler patent application. It does not require some of the most legalistic parts. And it basically allows an inventor to get their idea down on paper, get the invention down on paper, get the description down, file it in the patent office. The patent office gives you a filing date, says, here's, we received it, here's your receipt. And then the provisional application stays pending for 1 year. And once you've got that provisional on file, you've got a year to improve the invention, to figure out what the final commercial version of it's going to look like, to flesh out details, while at the same time you've reserved a filing date, you can disclose it, you can talk about it. There are a lot of advantages to provisional applications, and for many of my clients, that's the first stop. So what do we do? Well, when you're writing a provisional application, even though the patent office will rubber stamp basically anything it gets that says provisional application on it, and say, okay, thank you, we received your application. Ideally, you want to do it with some care and think about it. How do you do that? Well, next slide if you would. One of the things you do is you break down the invention, you deconstruct it. What are the fundamental parts? What makes this invention what it is? In this case, it was a base body structure with a number of slit-like openings. That structure has fur with a pile height sufficient to conceal the openings. In the photograph I showed you before, think about it. Mr. Potato Head, if you don't have a mouth on Mr. Potato Head, you see the empty hole. In this, it's got openings all over it, but you don't see any of them because the fur is covering it. And then finally, features that attach to the openings. So we got into the process of preparing a patent application, and this is one of our drawings. And the client here is himself a designer, so he did the drawings for me. And because it's a provisional application, that's not a problem. So we showed here the base body and the slits and the features that are attaching. Go ahead and go on. And so once we did that, we filed a provisional application. Now, once you, and this goes back to your question, once you file the provisional application, you can refer to the invention as patent pending. As I was kind of saying, you can disclose the invention to the public, and you can sell it without jeopardizing patent rights, as long as you don't go beyond the disclosure of the provisional application. Because, excuse me, the thing about a provisional is you are covered for anything that's in the provisional application. If you go beyond the disclosure of the provisional application, then you are jeopardizing your patent rights for whatever you just disclosed that wasn't in the provisional. So what I like to say is there's no substitute for thinking, choosing your business partners carefully, because the key thing to remember here is you may have filed a patent application, but you have no rights to stop anybody else until and unless the patent's actually granted. So that does pose issues for some people. In this case, they did something very important. They said, okay, we've got a provisional application, pending. We can talk about it. We want to raise money. So they did a Kickstarter campaign. And fortunately, their Kickstarter campaign succeeded. So they had some money to actually manufacture. So So far, we had a provisional application on file. In a blaze of glory, this client got a successful Kickstarter project funded, started to take the money and make the invention and actually get it out to people who pay for it, called Kickstarter, and try to license it to big toy companies. All those things were happening. 1 year later, the law and international treaties say, as I was saying, that once you file a provisional, you've got 1 year to file a regular application. So at 1 year, we went ahead with the process of writing a regular application. At that point, we went, okay, what's new in this? What do we need to add? What do we need to take away? We made some changes. We also had to write what are called patent claims. And I'll show you a patent claim in a moment, but a patent claim is the most legalistic part of the patent. It describes what the invention covers in very precise terms. So a patent claim is like if you do a piece of land. I claim all the stuff from here to here to here to here. Most of the energy in the patent office is focused on claims. Now, go back 1 second. I want to say one more thing. There we go. One more. Okay. And the other thing is, I was talking about international patent protection a moment ago. If you are interested in international patent protection, you must take action by that 1 year date as well. So usually what we could do is at the same time we file a US application, we can file an international application. But if you don't, there's a very specific international treaty. If you don't take action at 1 year from your earliest filing date, you pretty much can lose your rights to foreign protection. And unfortunately, as I said, it's expensive. It's $3,500 in government filing fees to file an international patent application. So it requires a little money, it can be useful. I was talking about patent claims. And the thing about patent claims is you want to have a combination of broad and narrow. So you start off by saying, okay, I want everything within this space. And then what happens in the patent office is, as you go back and forth, the patent examiner will say, no, that's too broad, I won't give that to you. Okay, I'll give that to you. So you need to sort of figure out how to cover the invention in a very broad way and in a very narrow way. I'll give examples in a moment. So this was the claim that I filed originally with the Hugalopes patent application. And if your eyes aren't bugging out from reading all the legalese, basically what I'm saying is base body structure with openings in it. The openings are slit-like. It includes a layer of exterior fabric with a pile height sufficient to conceal the openings. And then at least one feature having a connecting member in the shape of a button and an adapter to be put into the openings. A lot of words there, but very simple. Once we filed it, we waited. Much of that 3 to 5 year process that I was talking about is because the patent office is so backlogged that if you file a patent application, many times they're not going to look at it for 2 years because they're too busy examining the patent application that you filed 2 years ago. Now, in this case, it was about 14 months. That's really fast these days. Of course, when you're working with the government, everything becomes relative. So 14 months is fast. Yeah.
So with the big corporations like Apple and Google, are they like on a fast track when they come out with something and say they already have it patented? Mm-hmm. Is this, they're really saying patent pending, or they're like greasing the wheels?
Sometimes they're saying patent pending. A lot of times, companies like that can afford to file patent applications on everything. So if they even vaguely have an invention, they file 10 patent applications and that related. Until recently, it was very hard to speed the process along. You had to basically do the patent office's work for them and swear to them it was patentable and explain to them why and submit all the references you found. These days, it is actually possible to grease the skids. But a lot of, pay an additional like $3,500 to get yours at the head of the line. But these days, a lot of them do go to market with patent pending. Because who's going to mess with Apple? That kind of thing. Yeah. So that's that. Now, I've waited 3 years, 4 years for software. I have some cases of a software that were filed in 2004. So at this point, that's virtually obsolete. We're still trying to make some hay with it. Go ahead. So, the other problem is that you file a patent application, you wait 3 years to hear something back. And you hear something back, and what you hear is rejected. Rejected, rejected, rejected. It's all rejected. Every claim you filed is rejected. And by the way, you're allowed up to 20 patent claims in a patent application. So you know, craft claims of varying scope, but your first office action, everything's rejected. At least 85% of the time, patent application gets rejected at least once. I've had 3 cases that have gone through that were perfect first action allowances. Patent examiner couldn't find anything wrong with it. I had one that was about 2 months ago. The last time that happened to me was 10 years ago. So very rare that you're going to get everything through on the first pass. Usually there's some kind of issue that the patent office points out. And that rejection often has to do with your claims are too broad. If I give you a patent on that, you can go sue everyone. You know, it's far beyond the scope of what you actually invented or are entitled to. So let me show you what happened in Hugalopes' case. In the Hugalopes' case, we got a rejection. And the main reference was this Mobley thing I'm showing you over here on, let's see, your left, the left of the screen here. Mobley, and I'll summarize what it said, it taught this rigid vinyl doll that had holes where, you know, floppy ears could be put in. We're seeing that in this figure. But just, that was it. Otherwise, it was just a head with 2 little holes for ears. And then he found this furry teddy bear doll. And he said, look, it would have been obvious to combine the features of that one and add fur to it. You know, fur is very well known, and dolls with hard dolls and soft dolls are pretty much interchangeable. So the next question is, does that look anything like what I showed you at the beginning of the process? No. Okay, good answer. I see you shaking your head. That's good. So the next question is, why did that happen? Oftentimes, when you get something from the patent office, what the patent examiner is giving you just makes no sense. And you go, okay, is this examiner stupid? Is he on drugs? What's going on here? And the answer is, usually, the patent examiner is not stupid. Usually, it's about exactly what you said in your claim. And I know that all of you read that claim I put up on the screen very well when I put it up. So I'll just say quickly, my problem is, in my original claim, I never said that it was a soft toy. I never said it was a plush. So that was one of the problems. The other problem is, I never said in my claim exactly how many openings there are. So, we can go on. So the examiner finds this doll with 2 openings, and okay, that's a plurality. That's more than one, so it counts. What next? Well, I'll get something like that. And my first instinct, I'm very hands-on because I like talking to people, which is one of the reasons why I'm here today. So we call up the patent examiner. I'm sitting there with the inventor next to me, and the 2 of us are having this conversation with the examiner, and we're trying to make a deal with him. And in this case, what happened was, it didn't go very well. This examiner, he's an old guy who worked at the patent office, where I was like, yeah, I've got references that show that stuff. It's a crowded art, you know, it's out there. This is kind of like the equivalent of Joe McCarthy going, I have a list of 30 communists in the State Department. Well, okay, if you got something you want to show me, or shut up. So, and then the other thing he said was, you're talking about aesthetic features. This is all aesthetic. If you want a claim on a structure, on a thing, you've got to write me a patent claim that points out structural differences between what you want and what's out there already in the prior art. We finished that call. The client turns to me and goes, beat him. Burn it down. We're going to get this guy. And even I was really ho-hum. I'm like, okay. All right, that didn't go well. We're going to need to set ourselves up for an appeal. We're going to need to set ourselves up for going over the patent examiner's head. This is going to take a while. This is going to be a fight. You know, steel yourself, prepare for the worst. So when you get something from the patent office, you have to respond in writing. So oftentimes that response can be really quick and simple if you had a good phone call. Like I had a phone call once where I was trying to get patented a bookshelf that was trapezoidal. And I was talking to the inventor, and we came up with some changes that we thought we would make to make what we were asking for narrower and more reasonable. I get on the phone with the patent examiner, and she goes, sure, that's patentable. Hey, no problem. You want me to make the changes for you so you don't have to submit a written response? I was like, hey, great, less work for me. And then she says to me, by the way, I saw that you're associated with so-and-so. I used to babysit his kids. When you talk to her next, can you tell her I said hi? that was like my gold standard of patent examiner conversation. 5 minutes, the client gets the patent, and I don't even have to lift a finger to write a written response. Done. I love doing that. In this case, obviously we need to make some changes. So in this beauty of strike through and underline, now mind you, this is what I do all day, and somehow I can still see at the end of the day. What we decided to do is say, okay, fine, it's a soft, flexible structure, so it's plush. The openings are arranged in a defined pattern of patterns across substantially the entirety of the body structure. So what I'm saying there is, I don't care how many openings there are. I care that there's some kind of pattern, and I care that they cover pretty much the whole surface of the thing. Now, the other thing that I said here, I said body structure is hollow, and I was looking at it and I said, okay, having the general shape of a button, that's too narrow. So I crossed that out and I wrote, being larger than the receiving openings in at least one dimension, and being sized and adapted to be received in the receiving openings to secure the at least one feature. It took me a long time to write in this convoluted way. I'll just tell you that now. That said, I am the son of 2 generations of English teachers, and when I am not writing patent claims, I swear to you, I write in English, and I like real people to be able to understand what I'm writing. So, we submitted a response, and in the response, I went on a 10 or 12 page screed, because this guy, I mean, he just had so many attitudes that just needed to be stopped. And the client explicitly instructed me to beat him up. So we submitted this response, and we pointed out some of the differences between the invention and what he was pointing out in the prior art references. By the way, I've used the term prior art a couple times. When I use the term prior art, what I mean is anything that came before the invention. So if I've confused you on that one, my apologies. Basically, what I told him in the end was put up or shut up. Either show us these references that are magically out there somewhere that you think make our invention unpatentable, and give us the patent. So we submitted that back in March, and lo and behold, just yesterday, I got a paper that said, we win. If your negotiation with the patent examiner is successful, if you narrow your claims enough, if you convince him that your invention is patentable, you get what's called a notice of allowance. And that notice of allowance says, we're the government, you're not getting anything for free. Pay us $1,200 and then we'll give you a patent. The $1,200 is for small companies. For large companies, it's almost double that. So, by the way, there are 3 tiers of fees now. There's fees for large companies, there's fees for small companies. And the definition of small company is what the Small Business Administration says. It's pretty generous. Anything less than 500 employees is typically a small business. And then there's a separate fee category that just came into effect with the legal changes that's for basically independent inventors who have not been named on too many patent applications and made less than a threshold amount of income last year. Right now the threshold is $150,000. So, variety, please. Now, last thing I want to talk about before I let you get back to eating your lunch. And by the way, I don't have anywhere else I need to be today, so if you have specific questions about your own projects, feel free to come up. I'm happy to talk. Next topic, finding help. Oops, sorry. Yep. Okay, so most patent applicants who handle their own patent applications often get little or no patent protection because the process is extremely convoluted. It's difficult. There are a lot of rules. There are a lot of time limits where if you don't get a response in by a certain due date, then you lose your rights. So many ways to screw it up. I did work in the patent office for a little while as a patent examiner. I still have good friends who work there who are senior patent examiners now. And my one friend likes to call me up and go, Andrew, I have this independent inventor, and oh my God, I wish you'd just get an attorney or an agent. I wish I could send him to you if it wasn't unethical because patent examiners can't recommend particular patent agents. Because there's something in there, there's something in the application that is a good invention. I can't give it to him because it's not written well enough. And I can't get him to do what I want. Oh my God, he calls me like 5 times a week and he's driving me nuts. So, what do? 2 types of professionals can help with procuring patents. Now, the one you think of most is a patent attorney. A patent attorney is licensed by a state to practice general law. They've taken the bar, they've passed it, they went to law school, and in addition to that, they have a separate license from the US Patent and Trademark Office to represent inventors. Now, in this way, the USPTO is special and weird. It is one of the only government agencies that requires a separate license to practice before it, even if you are an attorney. Most other federal agencies go, okay, you're an attorney, good enough for us. This, they make you sit down and take a 3-4 hour test. Prove that you know all of their special rules. Now, it's a good way to segue into a patent agent is someone who has taken that test and passed it and has that license, but is not a lawyer. Now, in my case, learning this material is tough. And I started out, I was a young engineer. I broke things for a living, basically. My job was, reverse engineering things. Andrew, we installed the fiber optics, the aircraft carrier, but they're shattered. Tell us why. That kind of thing. But at the end of the tech boom in 2000, 2001, I was hired by a law firm. I worked for law firms for a couple of years. That's how I learned this. I worked at the patent office for a couple of years. And I've been running my own business for the last 8 or 9 years. So in both cases, patent agents and attorneys are required to have science or engineering degrees. You have to have a background in technology, or you can't understand the invention. You can't be of any use to your client. Now, of those two, patent agents are often cheaper because they have not gone to law school, so they don't charge the premium for that. So go back to cost for a second. Typically, I said $15,000 to $20,000 to get a patent in the US. Most of that cost is at the outset, actually writing the patent application, getting it on file with the patent office. And then whatever the remaining costs are really depend on what the patent office says. If I was able to get a patent with a 5-minute telephone call, it's probably going to be faster and cheaper than it would be if we had to go back and forth with several written responses. And there's a point, after the first time you get a patent office action, you're entitled to make whatever changes you want, and the patent examiner has to enter it, has to consider it, has to think about it. After that, the patent examiner is under no obligation to consider your response, and if you want them to look at it again, you may have to pay more money. So the costs can mount and mount and mount. Now, the other part of that is foreign patent protection is very expensive. Even after I've filed a patent application in the United States, and I send the text on to my guy in London, it's going to cost somewhere between $6,000 and $8,000 just to file it in Europe. It's going to cost that much money, oftentimes, to file it in Japan. So these are things that you need to be prepared for. Right? And that's where I stop for now. If you have any questions, I have business cards. Okay, go ahead, yes.
Royalties.
Royalties.
The problem of using technology that's already been patented. For example, some technology in the garage door opener.
Okay.
If you were to use that same principle and use it somewhere else, is there issues?
Yes, there are. The question was royalties, and the gentleman was using the example of a garage door opener, where, okay, if you have something, you use it elsewhere, is that a problem? Yes. The answer to your question is, it depends on how the patent is written. So if a patent claim is broad enough to cover different uses, then people potentially even in other fields would be liable for royalties or be liable for patent infringement if they didn't pay royalties and reach an agreement with the patent owner. And that is a big problem in the field. This comes up particularly in software patent applications because there are certain inventions, software is one of them, microchips are another, where the end product that I have in a package is covered by so many different patents, and there are so many different things going on that someone can come out of the woodwork and claim that you're infringing their patent. Happens all the time. Software patents actually, I think, derive most of their value these days from the threat of patent litigation, because someone will come up to a big company and say, look, I have this patent on, to use an example, speech recognition technology. And I think that your call centers are infringing my patent. So if you don't pay me a license of $250,000, then I will sue you for patent infringement. And once someone sues you in court, the costs are so high, a couple $1 million, that somebody can sell a patent or license it for $250,000 just to prevent a company from having to pay more money. And I've certainly had cases over the years where someone has come to a client of mine and in consultation with the attorneys who were handling it, I've said, look, offer them some token payment on the condition they never darken our doorstep again, rather than having to go to court and fight it out. Because the sad fact is that even if you have a patent, enforcing it in the courts is very difficult, especially for smaller companies, independent inventors. It takes money, it takes time. So, did I answer your question? Anything else? Yes?
About patent renewal. I have a friend who patented this invention.
Okay.
When we lived in Taiwan, and he patented it for years. And it was really expensive. He barely had enough money to keep it going.
Mhm.
And after a year, we found that Sony had just repatented, gotten a similar patent or something like that, bought patent off him when he maybe didn't renew it or something. Is it something that you would have to renew yearly?
Okay, that depends on, I'm sorry, the question was patent renewal fees. Do patents expire? Can someone kind of take it from me if I don't pay for it? What's the situation there? And the answer is kind of yes, so let me be more detailed. Most countries, other than the US, require a maintenance fee or an annuity to be paid every year to the government to keep the patent in force. And if you don't pay the fee, the patent lapses and it becomes part of the public domain, and anybody can use that technology without having to pay you anything. The US is as greedy as other governments, but they're a little bit nicer about it. In the US, we force patentees to pay maintenance fees 3.5 years after the patent is issued, 7.5 years after the patent is issued, and 11.5 years after the patent is issued. And after 11.5 years, we let it go to the full 17 to 20 without having to pay any additional fees. So if you miss those payments, then your patent expires and anyone can come in and take it. So one of the things you look at, and this is actually big in the drug industry, with generic drugs, is you look at a patent and you go, okay, when is this going to expire? And you've probably seen in the pharmaceutical industry that the second the patent expires, the generic drug companies start making generic versions of the drug. But yeah, if you don't pay at those intervals, then you lose your rights. I saw someone else was, yes?
Now, if you find a patent that you're referencing and you're researching and you're looking at, and it's similar or exists somewhat in Europe or another country, but not here, are you open to claiming that here in the United States?
No. Excuse me, water went down the pipe. The answer to your question is, well, the question was, if we find a product in Japan, in Europe, in some other country, and the invention exists, is it patentable here? And the answer is no, pretty much no. The rule is, if it exists anywhere in the world, and you can document, you can prove it, then you can't have a patent. And the difficulty that arises is, I had a case last week where I got an examination report, and 3 of the references were in Japanese. Okay, so I got to go translate. But no, anywhere in the world, you're out of luck.
So why?
Yeah.
So why would you need to get patents in these other countries? So
Well,
I do it here in the
because-
United States and patent it
Right.
and
So-
have it the rights.
Having something exist in a particular, having something in existence will stop anyone else from getting a patent. But without a patent, anybody in Japan can make that product. So they can knock me off all they want. That's the issue. Does that make sense?
Yeah.
Okay. And sir, you had?
Is there a long list of patent pendings for better mousetrap?
The shame of it is, I've been doing this almost 13 years. I have never actually patented a mousetrap. I feel like I've patented just about everything else, but
But you've had applications.
haven't even had to do an application on it. The patent office has its own classification system for patents, and they kind of like the Dewey Decimal System. They group patents for similar technologies together. And that even started, I think after this talk, I'm going to have to go online and see how many patents there are for mousetraps, because I know there's got to be a class and subclass for it. Yeah. Thank you. Anything else before we close for the moment?
Feel free to stay and chat.
I'll be around. I have nothing else to do, so if you want to talk about individual projects, get general advice, I will be here for a while. Nothing else? Okay. Well, thank you very much. I appreciate it.